Good afternoon, everyone. Welcome to today's webinar, where we will look at the updates to the Law Society's Conveyancing Protocols. My name is Aisling McPartland, and I am part of the marketing team here at InfoTrack. And I am joined today by Sarah Keegan from the CS Partnership. In this session, we will look at the changes that will come into effect on August 19th and discuss how to bring those changes into your conveyancing day-to-day practices. Before we begin this webinar, which should take no longer than 40 minutes, I'd like to draw your attention to the box on the webinar software that allows you to ask questions as we go through. Type your questions in here and we'll answer any of the questions at the end of the session. We will also be sending out a copy of these slides to all attendees at the end of the webinar. And I will now hand over to Sarah to present.
Thank you, Aisling, that's wonderful. And good morning, and Aisling just said good afternoon, but I had a bit of a flip out because it's still the morning. And it's lovely of you all to come and join us for this, because I know that you're busy and your colleagues are away and it's pretty hideous. If you can all hear me, that's brilliant. If not, raise your hands or say something. I'm not even sure if I can necessarily work out the technology to see if you're raising your hand, but I'll have a go. And the first slide there is just our slide about the CS partnership and the introduction, and the reason that I put it on is because two things. One, it always calms me down if I start just a little bit of a talk about this kind of thing about who I am, because it calms me down because I know that subject backwards, of course. And secondly, as lawyers listening, I think that it's a much easier thing to hear another lawyer talking to you than somebody that you wonder who on earth they are and what right they've got to talk to you about the law. I've been qualified since 1996 in property. And back in the heyday, I used to run 4,000 transactions a month. And I'm a co-founder of the CS Partnership. And the CS Partnership are legal engineers. We're legal engineers. And what we do is take the way that people's computer systems are working and your staff are working and your teams are working and the law, and then stream all of that and possibly take some of the things that aren't working away from you and make it a lot better. So Duncan Gadsby says he can't see the slides. I'm wondering if that's because of something I'm doing or not doing. So let's get on with the slides and see if I can make it a bit easier for you. So here we go. Now, again, you're going to have to bear with me because I'm a lawyer and not a techie, and I've just gone 3 slides forward and 2 slides back, which is always this sort of thing that I do. But let's look at the first slide, if you can all see them. The Conveyancing Protocol is taking effect from the 19th of August 2019, and it replaces the 2011 edition, which is quite a long gap in a new protocol coming out. The reason it's been updated is because it's pulling together the new CQS requirements that came into effect on the 1st of May. It's pulling together as well the DreamVar decision from May last year, the transparency rules from the SRA that came in December last year, the government's consultations on home buying and selling in December last year, 17, sorry, and the leasehold system last year itself, and then the revised code of completion that came in on the same day that the new CQS requirements came in as well. I'm not going to go through the CQS requirements because I did do a webinar for InfoTrack on that, and I'm sure Aisling will send you the recording if you didn't get to hear it. But basically, what it's pulling together is all of these new updates that are coming in through the different ways that conveyancers have to look at and behave, and then putting it into the protocol and saying this is how one pulling together for everything that we should be looking at. I've read the existing protocol as it is at the moment, although it's been taken down from the Law Society's website, and the new one, and I've done a comparison of the two, which is what we're going to talk through today. I find the new protocol much easier to read, actually, and it's quite friendly, and it has a lot of sensible stuff in it. And I know I'm actually realising as I say that I'm sounding a little bit as if I'm surprised the Law Society has issued something that's sensible, but it is. I like it. It's a nice piece. It's a nice document. It's very hard to compare the two because although they have the same headings in each one throughout and same sections, the say number 1 of the 2018 version doesn't quite compare at all to number 1 in 2019 version. So you spend a lot of time and effort going through the comparison, but it's not necessarily worth it. You can just read the 2019 protocol that's on the Law Society's website. It's got a very useful part on the website as well, because it will take you through to the CQS new requirements. They will take you through to a really good decision and dream bar note that they've got on the Law Society's website, and a comparison, actually, a good red line and strike out and underline version of the code of completion by post as well, which is very useful. Just so you all know, I'm sure you know anyway, the code is voluntary for non-CQS solicitors. But if you adopt the protocol in your transactions and you're not CQS accredited, if you adopt the protocol, then you are automatically adopting the code for completion. And so let's move on, because that's the nice background of it. I have to say that if you go onto the Law Society's website, which I'm sure you've done already anyway, but if you go on and have a read, it is very clear, it is set out nicely, and actually it's quite a pleasure to read the new protocol. But on the basis that everybody has no time and to look at all of these things all the time, and you're listening to me, let's go through what I think is the driving force behind the changes, and then a bit of the changes themselves. If you have heard me ever speak about anything, then I apologise that I'm going to reiterate some of this background behind the driving force of the changes, but I think it's really important. I think as a lawyer that it's nice to know why we do things instead of just being told that we are to do things. I think that we are a fairly argumentative set of people who like to make sure that something's right, and we've looked at it ourselves and we want to know why quite often. So my slide here says dealing with anti-money laundering and anti-risk has always mattered, but it's now that we're being held even more accountable than before as a profession. And the reason for that is because the world's changing. And we all know this, and I know you get bombarded with this kind of information a lot, but there's £100 billion a year currently being laundered through the UK, and an estimated 39,000 serious crime groups. And that always makes me laugh a bit, because I'm not sure how many crime groups put their hands up to be counted in some kind of assessment of how many there are, but nevertheless, there are about that many, and you know, that's a lot of work that goes through. When they say work that goes through, I'm told and I understand that there are people whose 9-to-5 jobs these days are to get paid to actually sit and try and hack, not just us, but all sorts of different people with phones and whoever it is that will fall for scams. So they will turn up to work and have their coffee and talk about what they ate for tea last night and what they saw on the television, and then their jobs literally will be to sit and hack and try and get us online to somehow give away our cash. So that is what the world is looking at the moment. And the National Crime Agency calls solicitors and other conveyancing professionals professional enablers, which is a harsh term, I know, to hear. But what they're saying is that basically we've got the toughest legislation in the UK in the world. And yet last year we submitted 2,660 SARs, which is a very small number of reports into the SRA, or the National Crime Agency, compared to £100 billion a year being laundered through the UK. Now, we know that there are a very small number of bad lawyers, as in naughty lawyers. 60 firms were referred to the SDT last year for potentially improper money movements, and 40 solicitors were struck off. But the long and short of it is, if we're moving money in conveyancing transactions, then the National Crime Agency says that we're unwittingly involved and that we're turning a blind eye. And on the back of all of that, our regulators are now being held accountable by a new regulator called OPBAS. I still haven't learned the words off by heart, so I've written it down again. It's the Office for Professional Body Anti-Money Laundering Supervision, and it was set up by the government last year in 2018. And its job is to look at the UK's anti-money laundering supervisory regime and then ensure that we are all complying with it. So OPBAS doesn't directly come and supervise law firms or practitioners in any way, but it is there to supervise our supervisors. So it's supervising the Council of Licensed Conveyancers and the Law Society and the SRA and ILEX, or Relief Executives. And that's a really big deal, because what we are looking at here is the fact that they are now being held accountable for what we are doing or not doing, basically. What they are being told as supervisory bodies is that it's all very well to expect us to have, or to ask us to have policies on the shelf, but actually if we're only submitting that many reports about what we think is suspicious behaviour, or if we're not actually looking at what we're doing on a day-to-day basis on the ground, we call it the coalface, at the coalface. If we're not doing that as conveyancers at the coalface, then we are now going, all of the regulations around us are going to be more stringent towards us. And we're going to be more inspected by the SRA and by all sorts of different bodies coming at us to make sure that what we say we're doing, what we're supposed to be doing. That's the point. I'm pretty obsessed about taking the things off the shelf as policies and putting them into the way that you're behaving as practitioners. So it's and one of the other obsessions that I've got to say before we move on to the actual protocol itself is that it comes from a long time ago. I sat in front of soccer. I was very newly in my job as head of department at a firm called Pannoni's in Manchester. I think I'd been there about 2 or 3 weeks. And soccer was coming to visit us because we had a file which had the mortgage deed had been signed by M. Mouse, which I have to say I found quite not funny. It's not funny. It's very naughty, but a little bit sniggery. Had been done many years before I got there, and I really was going to the interview in my head as the head of department to discuss all sorts of different things with whoever they wanted to discuss it with, and I wasn't in any way frightened at all that it was me that was going to be in any kind of trouble. And I sat opposite soccer. I know they're the NCA now, but I sat opposite soccer at the time. And within about 5 minutes of that meeting commencing, I remember thinking, oh, good gosh, I am actually going to prison. Oh, my God. And I didn't even do anything. And the seriousness of those gentlemen on the other side of the table was something I promise you, I wish that none of you ever go through. So if it ever happens, and it was, and at the time, I have to say, Pannoni's had done everything spot on. They had done nothing bad whatsoever. They were completely compliant with the regulations at the time. But the seriousness of the situation and those gentlemen, I will never forget that. And it's not a pleasant experience to go through. So when we're out in firms at the moment, we hear things like, I don't need to regulate, I don't need to look at this client's ID, I don't need to collect it, I don't need to do an online search to protect myself about them or the other solicitor, because I know the client, I know the firm that I'm dealing with. I've heard somebody say to me recently, and it was a head of department, but it wouldn't be me going to prison, it'd be the culp. And there's a lot of that's happening now in all of these different regulations coming at us and renewing and being pulled together and put in front of us in this protocol that make me sit and say, if anything else, take it very seriously, because we now need to stand back, look at the way that the transactions are being effected, say to yourself constantly, is that actually what we're being asked to do? I know that we're busy, and it's a fine line, isn't it, between having too much work and being on a reactive back foot, or standing back and saying, you know, we need to be on a front foot with some of this stuff, and we need to revise the way that we are behaving at the ground level. So let's have a look. Sorry, I like this picture. I put this picture in because isn't it the most pictorial thing you've seen about what I've just been discussing? About we're all on our phones. We can click with our fingers at any time and have something delivered to our front doors, or turn the heat up at what we're doing from the office, turn the heat up at home, or turn a light on, or deal with our money constantly online. You can see whether you've been paid, whatever it is. And yet there are people sitting there literally trying to work out how to defraud us and how to hack into what we're doing. And actually, you know what? It's hard for some of us because we don't behave necessarily in the same minds of the criminals. So we've got to actually at least look at the regulations. And I know I sound so boring, but I do feel very much as if I sound boring sometimes. But then you look at some stats. I got some stats. I read some stats from Lawyer Checker last week, and one of the blogs they put out was the fact that nearly 60% of law firms were affected by a cyber incident last year, and that's absolutely huge, isn't it? So anyway, my little soapbox aside, let's have some look at what's actually new in the protocol. I will say that it's very streamlined. It's very much, when you read it, if you haven't already read it, it's got a theme running through it of conveyancers taking charge of the timing of the transactions and driving the timing, and specifically even from the very first minute that your client comes anywhere near you, finding out what they've been told with regards to timing, from possibly estate agents or the best pal down the pub or whatever it is, but finding out what their expectations are, stripping them out and resetting them for them. They're quite into that they're quite vocal about, if they've been told the wrong timing and you know that that's the wrong timing, then you must go ahead and very much tell them some correct timing, really reset their expectations. And there's a very big thing throughout it as well of being polite and respectful to all parties. And actually, if something does happen where you think you won't be submitting, say, a search, if you're acting for a purchaser, you won't be submitting searches for a length of time, maybe, or a couple of weeks, maybe your client's on holiday, you're waiting for money in. For the searches, the protocol is very clear about from now on, and they want you to be very open and honest with the other side and with the estate agents, which makes me smile about the first partner that I ever worked for who thought estate agents were the kiss of death. But anyway, so it's all about also a real thing of not wasting each other's time as transactional lawyers. So if you've got standard inquiries, and they don't match exactly the standard inquiries in the layout, for example, that the other side has sent to you, then don't ignore theirs, answer theirs, and don't just waste each other's time for the sake of it. It's a real emphasis on stop behaving possibly in an old-fashioned way of this is the way we've always done it, so we always do it this way, and actually being a lot more proactive. And sorry if I'm sounding rude, but we all know the kind of lawyers we're talking about. People who are who will only do something in the same time that they've always done it. For example, sending out a transfer deed after exchange, when actually you could probably send it out as a seller's solicitor. There's a lot of that in the protocol, and I welcome it. Actually, I think it's a very positive and forward-thinking way of looking at conveyancing. It's obviously based on the government's questionnaires and things with 17 and 18. What else is new in the protocol? There's a lot less spoon-fed detail and a lot more blanket statements about regulatory requirements, like you've got to provide all information required by regulators, or ensure that you comply with your duties to lenders, or have a continuing awareness of potential cybersecurity issues, or make your clients aware of the fraud risks and the methods of avoiding them. I had a chat with somebody about this yesterday, and I have to say we spent a good 5 minutes just saying, well, how unhelpful that is. Because seriously, how unhelpful is it to say, have a continuing awareness of potential cyber security issues? But when you think about it from a practical perspective, the Law Society is following the same method, the same ideology that the SRA is bringing out their new code stars in November, because at the end of the day, I've heard the SRA talk about this, and what they say is the world is moving too fast now for us to have a format from either the Law Society or any of them, actually, the SRA, whoever it is, that says you have to have done X, Y, and Z. Because if they set out you've got to have done A, B, and C, then by the time we all turn around, somebody somewhere will have had a problem with D, E, and F, and the Law Society hasn't set that in the protocol, and it takes them too long to issue a new protocol and new CQS requirements and new anything. So what they're basically saying instead, just like the SRA are doing for changes coming in November, is you are statutorily bound by some of these requirements, and as practitioners you need to know that. And actually, since you need to know that, then it's on you to read it and make sure that you're pulling it into the way that you are affecting your transactions. So whilst it's unhelpful, I understand it. And there you go. The 2018 protocol was 41 pages. It's been stripped out. It's now 32 pages. And that's quite a big difference, actually. And it's quite a lot, as I said, it's quite a lot easier to read. And it makes a bit more sense. One thing that hasn't particularly changed is the risk element. The same risks, they're asking you to look at the risks and to make the risks on each transaction. But the thing that is different is that they're clearly stating that the risk obligation continues throughout the transaction. It's not just at the beginning. So you don't just open your file, and I've seen this, open the file and have a set risk policy for each conveyance of medium, so low, medium, high. Well, we're going to pick medium for everyone that we open because it's conveyancing, so it can't be that much of a risk. It can be that much of a risk, as we know. And what they're asking you to do is have your policies and procedures throughout each transaction so that the fee earner is looking at risk, or the fee earner or partner is looking at the risk and taking that risk. Now, for my mind, that's quite, you can have checklists throughout transactions. You can ask your conveyancers to pause and to look at what they were told at the beginning of a transaction, and to feel, and I know feeling is not really something that protocol would ever think about, but to feel themselves about what they've been told in the transaction from their clients, what they were told at the beginning, and whether their gut feeling is a bit off on that, and to speak to somebody, a team leader or a partner in charge. But more than that, you can also pull somebody like Rob Hailstone's industry red flags and put them into your case management systems if you've got case management systems, or checklists if you've got those, and have a feel again about whether something is pushing you towards it. It's got to be spoken about, or you might want to stop acting, or whatever it happens to be. But the long and short of it is, this is a time when we are less reactionary now, and actually looking at what we think is the right thing on a file by file basis. Firms that we know and we're working with, and firms that we hear about, are being inspected and found wanting with regards to those risk assessments throughout transactions. So the SRA is no longer wanting us to just say, we've done a file assessment. It's at the beginning of the file, here it is. They want you to write it down. They want the fee earner to have given their reasons for the file being assessed at the level of risk it was assessed at, and they want it done more than once. So we are advising people to be doing their risk assessments as fee earners at the beginning of the transaction, just before exchange, and just before you move money at completion. So that's what we're saying at the moment, which is good. What else is new in the 2019 protocol? There's a real focus on what the issues are that cause insurance claims. So we know, we can feel that as you read it, you'll feel it. You'll feel what the insurers are finding in conveyancing, and you'll see it in the protocol. So, for example, there's quite a lot of detail about how to deal with restrictions appearing on the register. I absolutely know that everybody listening to this is an InfoTrack user, in which case you have got a lot less problems about that kind of insurance claim, because of course InfoTrack's got really cool. I'm not sure if I'm going to be laughed at for calling technology on a property cool, but it is cool. It makes me want to practice again the stuff about the AP1 that you've got. But that kind of information is one of the biggest insurance claims, as you know. Not dealing with your restrictions properly, well, that is a big insurance claim. So all of those restrictions requisitions from the land registry, the restrictions on the register themselves, they've got I'm just having a look as I read this, that you've made a record of the advice given to clients at all stages, the advice to the seller about continuing to make mortgage payments, ground rent, service charge payments up until and including the completion date. They've got a lot of different advice throughout about the buildings insurance, and how early you advise your clients on buildings insurance, and how much it has to tie in with what your particular lender is saying, and again, defective title indemnity insurance. And they've got nice new bits about valuations and surveys, and advising clients very clearly right at the front of transactions about the fact that any valuation is for the lender's benefit and not for their benefit. So there's some, but they're very practical things. They're not about cyber risk. They're real down to what actually goes through on an insurance claim most of the time. Those particular bits. You can tell as you read the protocol, you'll pick up the fraudulent sellers in the Dreamvar position and the new code. You'll see that very clearly as you go through. The new code the new code of completion doesn't actually change what happened. Dreamvar didn't change what happened with regard to the seller's liability. In other words, Dreamvar basically said, as you all know, that the seller solicitor is responsible for making sure that the seller is genuine and that the transaction that they engage with is genuine. And I know that you will, we first frightened, weren't we, when we heard it, that as a purchasing solicitor, you would then want to caveat that out, or as a selling solicitor, sorry, you'd want to caveat that. But of course, you're also acting on the other side as a purchaser. Each time you do that, you're going to be selling and buying. So what the Law Society's advice is to stand back, to be calm, to know that actually we have always been giving quite substantial undertakings on conveyancing matters. I mean, we really do put our lives on the line every time we do a conveyance. I don't know why it's always treated as the dog end of the world, but it shouldn't be. But the long and short of it is, when you should be using, and to my mind and to my advice is that you should be using some kind of independent check on ID for technology check. And the reason I say that is because, again, I know that you're using InfoTrack, but the figures out are that 5% of sole practitioners are using independent searches to check ID, and half of the big firms are using independent searches to check ID. And that's quite, in this day and age, that's quite a frightening set of statistics there, because there's no reason why you shouldn't be using those. Please do if you're not already. That's quite a big risk, actually, to say, to be looking just yourselves at somebody's ID and tend to be looking at the person opposite you and not to have a verification independent of yourselves would bring me back to my point I was saying about if you ever do sit in front of the NCA and they are talking to you about whether you thought what you'd done is good enough, with the technology and available in today's date, I'm not so sure that you would be able to put your hand on your heart and say we did everything possible. So that's the kind of advice I never wanted to say. They do weirdly warn about how to submit your bank details, or what they do actually say it's not a good idea to send your bank details to your client or to anybody for that matter by email, which is correct, but they don't then go on to say what you would do differently, and I suppose they're not going to either. I always advise to speak to people on the phone, FaceTime them, tell them at the beginning of the transaction that you will never change your bank details, unless you are, of course, unless you're just about to. But tell them you're never going to change. Tell them that on the phone when you speak to them. Tell them why. Rewrite the initial documents that you send out to clients to explain it, because I don't think there's any harm this day and age with actually saying to people, we are Blogs & Co. We've been doing conveyancing for this many years. We absolutely want to work with you. We want to look after you. And one of the things we're not going to do is allow you to be the subject of fraud if we can possibly help it. So we are going to be coming across as a little bit heavy-handed with some of these things, but we want to do it because we want to care for you and look after you. And I don't think in this day and age that we should be ashamed of saying that. And I also don't think that's going to turn your clients off. I really don't. And if it does, then they've got the wrong end of the stick, really, haven't they? So what else is new? Let's move on from me waxing lyrical on stuff all the time. The new CQS requirements are reiterated throughout protocol. It's quite refreshing to see them, actually. But the CQS requirements themselves are a lot more detailed. It's just picking up and putting the same elements in about the policies that you've changed from May onwards. So looking after the interests of the lenders just as much as you're looking after the interests of the purchaser, ensuring that the requirements of the lender and the interests of the property are protected as you register their charge. Very big theme of reporting the matters to lenders, just in line with the CQS requirements, and also with waiting for lenders' approval before proceeding. Again, with the stamp duty requirements, specifically with this is quite a strange one actually. Specifically, they're asking you to either advise the buyers in relation to the potential tax liability or advise them to obtain tax advice. And also very carefully advising them as to the order of transactions if the transactions aren't simultaneous, because the 2018 protocol was very clear that you should be giving clients advice about how to break the chain in property so that you could move them faster. That's gone. That's absolutely left now. This protocol is very clearly saying, be careful how you advise them in case you're asking them to pay extra money because of the way they're holding property or not holding property. And just as regards to CQS, there's a lot more information with regards to leasehold as well, and the new FME1 form, which is freehold management inquiries, isn't it? And that's again also free on the Law Society's website if you haven't read it already. And clear requirements to advise the seller as well as the lender about the terms of lease and considering the lender's requirements with regards to leasehold. But everything that I'm not going to go over the CQS elements because I'll just be repeating myself from May this year, but it is very clearly reiterating those elements. So let's have a very quick look at what's been removed, because what's new is that it's faster, sharper, a little bit leaner, a bit more broad brush, a bit more asking you to go off and look at your own, look at everything and stand back and then work out how you are assessing risk throughout the matter and how you're behaving to clients and how you're communicating with everybody. It makes me feel a bit, It's not one of those things where you think everybody's having a go at solicitors. Actually, it doesn't come across like that. So it comes across as if really we do need to be communicating with everybody. We do need to be driving it. That's the way it feels. It feels like they're asking us as conveyancers to be in the driving seat as opposed to reacting to things. So for example, I spoke to a law firm yesterday, and actually they're asking us to run task lists, say, before you open your post and deal with that. That's the kind of thing they're looking at, really, for a practical basis. But what's been removed is details like how to save documents and how to scan documents into the case management system. Like I said, details about how to break a chain or using pre-contract or reservation agreements, that's gone. They've removed the advice about how to request money on account. They've removed just advice about whether the buyer's in rented accommodation and needs to serve notice, which actually was quite a good one. But anyway, weirdly, they've removed the advice about making sure that you've advised your clients on the financial contributions of different parties as they're purchasing property together as joint tenants or tenants in common. And even more strangely, they've removed the third-party funding advice if you've got the bank of mum and dad gifting. They've removed all of that. So that's a bit odd, but I suppose it sweeps up into you must be dealing with the, say, the money laundering requirements 2017. So maybe that's the logic behind it, but I did think that was a bit odd that they've removed it. And they've also removed considering whether the sale is taking place within 2 years of a previous registered transaction or whether the seller is not yet registered. And I wonder, I don't know why. I mean, I quite like those things. But anyway, now I do sound like a bit of a geek, don't I? Sorry, I sound like a bit of a geek of what I do and didn't like. So there you go. What we can provide to assist if it ever, what I would say to you is have a read, have a look at it all, work out then how you would want to reverse engineer what is being asked of to how you would look at it on a ground level. I'm going to be preparing in the next couple of weeks really thorough client questionnaires on a sale transaction and client questionnaires on a purchase transaction based on everything that the protocol is actually asking you to collect from your client up front, because it does. It asks really clearly, get this information up front, put it into your risk assessments, or think about it from a risk assessment perspective, and then actually go ahead and go transact, obviously carry on as you were. So I'm going to be drafting initial client questionnaire on a sale and on a purchase, and a checklist on a sale and a checklist for a purchase to be repeated throughout the transactions. If you're interested in any of those, do contact us on the inquiries at thecspartnership.com. I figured that I would also tell you about our CQS policy pack, which I know some of you have purchased, just because it's already in existence and it's sitting there and waiting to wing itself towards you guys. And then finally, we are drafting or have drafted already a full sale and purchase letter suite for transactions, but we are going back through those in the next couple of weeks again to make sure that they're CQ protocol compliant and tweaking them accordingly. So that's what we've got available if you're interested. But if you just want to raise questions or ask anything or have a chat on the phone at any point, just send us an email at inquiries at the CS Partnership. And those are all of our details there. And actually, I've done that quite fast. I've done that all right, Aisling.
Yeah, it's great. I think there is, I don't know if you can see the Zoom webinar chat there, but David Kersley he did ask a question there, if maybe you want to touch upon that.
So David Kersley says we do email account details to clients and solicitors, including the fraud one saying the share is verified. Absolutely. I think that's good, David. I think that, absolutely, I think that sounds okay to you. And the reason is because, you know, if you're used to somebody's voice on the phone, like for example, I know Aisling's voice. If I email my document, my account details to her, and then we speak on the telephone and we verify that to each other, that's absolutely fine. I think that's okay, to be perfectly honest. I'm happy with that. It's the I think what you're trying, what I think practically what I'm trying to say is you're saying to your client, don't ever speak to anybody about this stuff unless you know, don't listen to Bob who suddenly says David's off today, but he'd like you to send the account to X. That's what I'm trying to say. But yeah, do it. That's great.
Great. Sarah, thank you for your time today.
You're very welcome.
that you all found it very informative. And if any other questions, please, if you've put them in the question function, we'll get back to you by the end of the day. And if you have any more questions, please email Sarah, your account manager at InfoTrack, or myself. And thank you all, and we look forward to welcoming you to another webinar soon, and I will be sending the slides out by the end of the day.
Brilliant.
Great, thank you.
Thank you.
Thanks, Sarah. Bye.
Bye.